Mr. Hill?
May it please the court, counsel. The issue before the court today is one of the earned time accumulation rate for juveniles who have been convicted of 902.12 offenses and who have been resentenced after Lyle. What this really means is what is going to be their earned time rate. Are they going to earn 1.2 days for every day served or 15/85 for every day served? In English somewhat, this is about a 40% reduction in their sentence. The question was presented to the trial court.
Can you answer a question for me? Why did they come up with 15/85?
15/85, it's a great question, and it comes down to a math answer. In order to get earned time, the earned time should only apply to the first 85% of the sentence. And so if you apply the 15/85 to all of the days, 100% of the days, you get about a 17% reduction in sentence. 15/85, if you do the math, it will equate so that if the person earns every day and never loses a day, he will actually discharge at 85%.
Yeah, I did the math a little differently, and I took a 50-year sentence with a 35 minimum, 70%. And if you do the math, it turns out that 7.5 years into that last 15 years that are not mandatory, you get out. So you end up getting a day for a day, basically. I mean, that's what the math is. It turns into a day for a day for a non-mandatory minimum, for the non-mandatory part of a minimum sentence.
All right, and I'm a lawyer, not a mathematician, and I understand that, and we've worked the numbers, and that's how they come out. It does work out that if you earn 15/85 for 8.5 years, that equates to a 10-year sentence.
That was done that way because you want to have some kind of hook. Hook's a bad word, but some kind of incentive for someone to be good even though they can't get out for 30 or 40 years. But at least when they start in the non-mandatory minimum part, they'll get a day for day, like if they didn't have a mandatory.
No, they don't get it day per day after
Well, it turns
yeah.
out to be a day for day on the non-mandatory part. That's what the math does on these sentences.
I disagree, and I've had cases before where I present the whole mathematical equation of how we get the calculation, and the Department of Corrections breaks it down to 6 decimal points, and we can do the actual paper math.
I only did it to 2 decimal points, so.
Okay, well, it works, and we get these challenges at the district court level all the time of figuring out the sentence, figuring out the jail credit, and that's what I spend a lot of my time on, but.
I'm sorry, go ahead.
Counsel, yeah, I'm going to follow up on Justice Wiggins' question. Did they do a different or a slower accrual rate for sentences with mandatory minimum to avoid a situation where by behaving and accruing good time, you'd be otherwise eligible for release before the mandatory minimum term had run?
I think I understand your question, and to me, there's a difference. Remember, under 902.12, these are what I call minimum sentences. It's a hard 70. Earned time doesn't reduce it. In a normal situation, what you would call a mandatory minimum under a drug offense, it's reduced by earned time, so that mandatory minimum gets cut to 45.45%. Minus jail credit, and so it ends up being a pretty low number.
Well, let me ask it this way. Why did the legislature provide for 2 different accrual rates?
Easy answer, because the type of offenses. The type of offenses that it applied to were the most heinous offenses. It put 2 hooks in them, so to speak. One was that you serve 70% of your sentence before you're eligible for parole, and the other one was the 15/85 to increase the amount of time that you actually spent in prison. And it kind of makes sense from a legislative perspective of the offenses for which 902.12 apply are some of the most heinous offenses. They're the murder second, the attempted murders, the robbery first and second, kidnapping second, sex abuse second.
Here's the question, Mr. Hill. I mean, I don't want to belabor the math too much, and I haven't studied the numbers probably like my colleagues have, but so if Mr. Allen's client prevails, as I understand the situation, what we've already done is said there are no mandatory, that what the legislature considered a mandatory minimum for a given sentence as applies to juveniles, is no longer a mandatory minimum. What would now happen is it would no longer be a maximum either in some of these cases. Is that right? Because there would be enough earned time that you would get below your release date would end up being less than or earlier than the period of the mandatory minimum. Is that right?
To give you an idea for Ms. Breeden, her current tentative discharge date is November 14th, 2023. If the court were to rule, as the Court of Appeals ruled, that she gets 1.2 days from the very start, she would have discharged in 2013. Same thing with Ms. Hoochmouth, although she has a longer sentence, her TDD is the earliest she could discharge with all potential earned time credits. Currently is July 2nd, or July 26, 2040. Her new discharge date with 1.2 from her very admission would take her down to May 21st of 2021.
Are these provisions severable, for example? I mean, you mentioned two hooks. These are heinous crimes. We're going to, require the 70% or the mandatory minimum, and also the slower accrual rate, the 15/85 instead of 1.2. If we take away in Lyle the mandatory minimum, can we still use the slower accrual rate under our general duty to save as much of a statute as possible if it's severable?
Yes. I think the two provisions, both the 70% requirement and the 70% requirement that they serve 70% before they're eligible for parole, it's a minimum sentence, earned time doesn't apply to reduce it. That provision itself is separate and distinct and operates.
Well, but counsel, you describe it as separate and distinct, but this court back in 2000 characterized that, the combination of 903A2 and 902.12 as an aspect of the mandatory minimum. And the whole rationale for resentencing this person is to get rid of that. And so, based on what we've already said about the combination of these statutes, isn't the conclusion foregone here?
I think what you're referring to is in the commutation case, the Lowry case.
Yeah, but it's the case I'm referring to is State versus Iowa District Court for Black Hawk County.
Okay.
It's a 2000 Iowa Supreme Court.
Right, and in Black Hawk County, that's when they were one. It was a true 85-85. That is, you had to serve 85% before you're eligible for parole, and you could only earn time up to 85%. Then it went down to 85-70, and what I think the Black Hawk County case recognizes in its progeny is they separated those two aspects. That's the point where those two diverged, and they said you have two distinct and separate aspects. You have the minimum sentence, and you have the minimum parole eligibility. And the argument that I have in what urging the court to adopt is certainly while Lyle got rid of the minimum parole date of 70%, the other aspect, the 15/85, remain viable. And it's the viability of that aspect is because of, I think what you have to do is mind back to what's really at issue in this case. Why did they have the 15/85? And the reason was because of the nature of these crimes. These were the worst crimes. We're going to make sure that these people do longer in prison. Doesn't mean that they're not going to be eligible for parole if they were juveniles, because in this particular case, both petitioners, Breeden and Hoochmouth, are now out on parole. So in essence, Lyle worked. These individuals are out on parole and hopefully doing well.
Does that make this case moot?
No, I don't think so, because the court also has two other cases here today. One's still in prison. I think it's the type of issue that we need a resolution for, because we have this subclass of, like Anderson versus State, the probation credit deal, where we have to deal with these folks, and the interest of the Department of Corrections, the state of Iowa, is to get it right and to follow the law. And what we think the law is that they set up this system whereby there's these two sets of offenders, those who commit normal offenses and those who commit bad ones. And for those who commit bad ones who are juveniles, we're gonna make them parole eligible, we're just gonna have a longer period of supervision for them. And that's really what we think the legislative intent was, looking at the entire picture of what was going on to these particular offenders, is that because of the type of offense for which they were convicted, is that these are the types of individuals for whom a different earned time rate applies. And that's what we would assert is consistent with Lyle, consistent with the statutory language. Understandably,
Did we already decide this in Lowry?
in Lowry is a difficult case because it was decided upon the language of the commutation, and the court in Lowry kind of split it halfway. Because Governor Culver had some language saying that this guy should be vetted by the parole board, so therefore maybe we didn't mean to. Lowry, I think, from one, can be limited to the fact that it's a commutation case and be looked at from that angle. If,
You know, the second half of Lowry, we said, from the date of the commutation order henceforward, Lowry is entitled to earn time at the faster rate. So why, if we apply Lowry here, why don't Breeden and Hochmuth, or not them, but whoever really needs the relief, why aren't they entitled to the same faster rate?
well, the reason is because I think you got to go back to the statutory interpretation. I think Lowry in the big picture was decided as a commutation case, and there was no, I can't remember the time frames if at that time Lyle had been decided, the potential impact of it. I think at the time,
I'm not sure that it had been, but nonetheless, the issue, essentially the state prevailed, but in getting the slower earn time rate, but only on the theory that the governor had not intended that Lowry get the faster rate up until the date of the commutation. Or after that, Lowry got the faster rate, which seems to be consistent with the positions that Breeden and Hochmuth are arguing here.
right. And I think if you say that Lowry is the end point, then Lowry needs, the rationale underlying Lowry needs to be reexamined pursuant, because there's not this statutory analysis of, gee, what was the legislature intending to do here? Because it almost seems as if we look at how we're getting to this point is somewhat of an unintended consequence of Lyle, is that.
But is it really, you know, when we say the sentence originally given was illegal, we replace it with a legal sentence. So you got a brand-new sentence, and the brand-new sentence is not subject to mandatory minimums. The language of the code is, and it's in 903A2B, says, sentences are those sentences which are subject to a maximum accumulation earned time of 15 under section 90212. And it's referring to 90212, but when we replace the sentence, it's no longer a 90212 sentence. So by replacing the sentence, I don't know how the language of the statute gets you back, and maybe I'm reading this wrong, but how the language of the sentence gets back, because you no longer have a 90212 sentence. And I think the law is, and maybe I'm wrong here and you can explain it to me, is that the new sentence took the place of the old sentence, so you never had a mandatory minimum sentence.
That's because in what we're arguing about and what you'll hear from counsel here in a moment is it's the sentence. What we would argue is it's the conviction. These individuals were still convicted of a 90212 offense. They were still convicted of these heinous offenses for which they have a slower earn time rate. And if one were to look at the true statutory interpretation, instead of kind of jumping from what was the sentence to, basically the argument is.
The statute uses the word sentence, not conviction. It says a sentence pursuant to that section, not a conviction pursuant to that section.
But we're looking at the sentencing statute, not the earn time statute. And the earn time statute says 1585th for this type of offense.
For a person sentenced under that statute, not convicted. They don't use the word conviction.
And I understand. That's why we're at this loggerhead that needs to be disputed, and we could argue this point all day about which should control 90212 or 903B and what was in effect. But that's why I think one has to mind back to what's the intent of what the legislature wanted to do. And it's the position of the state that what they wanted to do in this case was to hold these individuals accountable and have a longer string over them. So we would ask that the decision of the district court be affirmed.
Thank you, Mr. Hill. Mr. Allen.
Thank you. May it please the court, Counsel Hill. Listening to the court's questions, unless they're rhetorical, I have to ask, why am I here? To get to the department's position, I think you have to ignore the clear reading of the statute. You have to ignore the district court's order, which in handwriting, the judge said, let the Department of Corrections be very clear, there is no mandatory minimum. You have to ignore the sentencing structure. You have to ignore Lyle's decision, which says no one-size-fits-all for these juvenile defendants, and what the department's what the department's interpretation is.
You know, I mean,
one size
I
fits
think
all.
reasonable people can disagree on this argument, on this issue. What we're dealing with is the legislature has one statute cross-referencing another, and the cross-reference says the Category B sentences are those sentences which are subject to a maximum accumulation of earned time of 15% of the total sentence of confinement under Section 902.12. And then 902.12 lists a series of offenses and says the person serving a sentence shall be denied, for these offenses shall be denied parole or work release until they've served 7/10. So you want to emphasize the fact that the legislature used the word sentence, but one could arguably just say it was a convenient way of cross-referencing that particular list of offenses, right?
Yeah, it's a convenient way of cross-referencing, I understand that. But when you get back to 902.12, as Justice Wiggins pointed out, it is no longer a 902.12 sentence, because the language, except for juveniles who have been resentenced, has been juxtaposed onto that.
I mean, we can, I think if you're right, if we apply a strict blue penciling approach, you're probably right.
Well, it's a constitutional requirement.
Well, but normally when we we declare part of a statute unconstitutional, we try to save as much of the statute, as much of the legislature's scheme as possible. Here we declared the mandatory minimum unconstitutional as applied to juveniles, but we've also now, in effect, shortened the actual sentence based on the earned time accumulation.
Well, let me offer two reasons for that. One of which is Lyle stands for the proposition not only that mandatory minimums shall be eliminated, but the reason that mandatory minimums are eliminated is because the one-size-fits-all for all juveniles is no longer applicable. What the department's position is on the earned time is that for these juveniles, despite the fact that they have had their mandatory minimums removed, they are still treated as one-size-fits-all. They all get the 15/85 instead of the 1.2, so they're still being treated in conflict with Lyle. Secondly, when you put that into the statute itself, what you've done is you've created what was originally unconstitutional, and you've now, because you want to make the switch from one statute to the other, because the legislature made the reference, you've transferred that unconstitutional one-size-fits-all into the sentencing statute, and you've done that for the very reason, as Mr. Hill points out, because it's an additional hook, because of the nature of the severity of the crime, or because these are heinous individuals. All three of those criteria are in violation of Miller. Miller says those criteria for juveniles should be considered by the juvenile court, by the sentencing court, which they were, because no mandatory minimum was imposed.
But are we dealing with a constitutional case today, or are we simply dealing with statutory interpretation?
Well, as you can see by my resistance to the application for further review, my constitutional argument is on the tag in, because we don't get to it, I don't think, because we're limited by the statute itself. The statutory interpretation, if you look at it, as Justice Wiggins pointed out, you look at it, it is a sentencing guideline statute. The word conviction, Mr. Hill can't find it. The word crime, it's not in the statute. The statute itself, you just read it. It is a sentencing category. And if you have a Category A sentence, which has no mandatory minimum, or if you have a Category B sentence, which may have a mandatory minimum, then you impose and you apply the statute as it's written. You don't even get to 902.12, and if you get to 902.12, then the constitutional argument may arise. But I would suggest that under long-standing statutory interpretation, you just follow the statutes that is there, which simply says the word conviction, the word crime is not there. We're not looking at the heinousness of their acts. We're looking at what is the sentence that they are now serving. And both of these individuals, because of the resentence by the district court, where she put in no mandatory minimum, neither of these individuals are serving mandatory minimums, and when you apply 903A.2 as a sentencing category, they are getting the 1.2. Does that mean...
Counsel, if we think the statute can be read either way, and then look at our other tools of construction, including the purpose of it, what was the legislative purpose of having the 1585ths for the more serious forcible felonies?
I think Mr. Hill is accurate on that. I think the legislative interpretation, legislative intent was for heinous crime back in the day when we did mandatory minimums for a heinous crime. For these particular individuals, we wanted to make them sit there a longer time. But for the juvenile class, for those individuals who got resentenced because of the policy underlying Miller and the Iowa cases, that no longer applies.
But they're still resentenced for a conviction that's listed in 902.12, so why aren't those provisions severable?
Well, fine, but you can't get from, it's like trying to get to Cedar Rapids in a flood season. You can't get there from here. You can't get from 902.12 to the sentencing of 903A.2 because the word conviction, the word crime, the word heinous is not in there.
You can't rely on the statutes alone and get to the outcome we got in Lyle. Well, the point is we declared aspects of the statutes unconstitutional. We now have to try and
I understand.
Put together put things back together, be faithful to Lyle, but also preserve as much of what the legislature intended as we can.
And let me also suggest that we need to preserve as much of Lowry as we can. Lowry has already answered this question. For purposes of commutation, Mr. Hill would like you to believe that commutation is somehow different than resentencing. But for that period of time, subsequent to the date of the commutation, as you suggested, Lowry has already answered this question. Lowry says, if Lowry had been sentenced to a term of 25 years with no mandatory minimum, he is entitled to the faster rate. The new sentence gives effect to the plain language of the statute. That is exactly what happened to these individuals. They were sentenced to a term of years with no mandatory minimum, and according to this court's pronouncement in Lowry, they are entitled to the faster rate.
What
the
about
decision's already been answered.
I know we said that in Lowry, but what about your opposing counsel's argument that we should distinguish Lowry as a commutation case, and maybe one way to look at it, maybe, is that Lowry didn't invoke this duty to save as much of a statute. It was a one-up governor exercising his power to commute a sentence. It's not like this part of the statutory scheme is unconstitutional. Does that take down the other part, or can we separate them? Different question?
I think it's a totally different question, and Justice Waterman, I can give you that for purposes of that portion of the sentence which occurred prior to the commutation. In that particular instance, the individual Lowry and the individual Breeden are exactly in the same situation, mandatory minimum. But for that period of time, subsequent to the date of the commutation and the date of the resentence, they remain the same. They neither one have a sentence with a mandatory minimum. They neither one are subject to 902.12. They are under 903A.2. Neither have a mandatory minimum, either subsequent to the commutation or subsequent to the resentence. It's a new sentence, replaces the old void, and so consequently they are under 903A.2 entitled, under Lowry, to the faster accumulated rate.
I can ask Mr. Hill this, and maybe I should, but do you know what is going on with folks that we're not talking about a resentencing, but they've been sentenced for one of these more serious crimes even after the legislature adopted the 905.14 provision. are those folks under DOC policy accumulating earned time at the slower rate or the faster rate?
You'll have to ask Mr. Hill that. The portion of your question that I can answer is that there are a lot of Breeden and Hochmuths out there. There are a number of cases from Scott County that are sitting around waiting for the result in this case. District court judges are generally applying the faster rate because they're reading the statute. The Department of Corrections is responding to most of those in the same way they're responding to this case. So that of the 45 or 47 juveniles under this court's cases that need to be resentenced, they will all face this problem because the department is taking a uniform position that they all get at the slower rate, not the faster. Based upon what I believe is clear statutory interpretation to avoid the constitutional problem, and because Lowry and the principles and policy behind Lyle control this, I think the Court of Appeals had it right when they said clear statutory instruction, these people are entitled to the faster rate for that period of time. For Ms. Breeden, as Mr. Hill has already pointed out, 2.5 years ago she would have been discharged. Is this case moot? No. She's continued to be under parole. She's continued to have to report. She's continued to do monthly and weekly surveys. She is continually under the jurisdiction of the Department of Corrections and will remain so until 2023 unless this court affirms the Court of Appeals. Thank you.
Mr. Allen, thank you as well. Rebuttal, Mr. Hill?
Begin by just quickly answering my question. Is DOC taking the same position even as to juveniles, say, that currently commit these more serious forcible felonies and are sentenced?
Yes. And by, estimates, we know that this case only involves 2 individuals. We have Mr. Coleman and Mr. James being submitted non-orally. The estimate is there's about 150 people who are fit in this class of juveniles resentenced under 90212 that are out there. What I think the problem that the court has is we're basically trying to reverse engineer 90212 and 903A.2 based upon the subsequent Lyle decision and trying to apply it to an issue never envisioned by the legislature. And that's why I think one has to go back to what the legislature really intended. If the words are, if we're fighting over conviction and sentence, we can't read all logic out of the statute to get a result which doesn't seem consistent with what was intended. And what was intended was, for this class of offenses, they wanted a longer period of control over them. And this really does fit hand in hand with the Lyle decision. Lyle decision said we had nothing to do with the length of the sentence, we just want to give them the opportunity for parole. And as evidenced by the 2 offenders in this case, they're both out. And they're both doing well, they're just under a longer period of supervision. Will they be under that period of supervision forever? No, there are certainly, if they've received maximum benefits, there's provisions under the parole code which allow them to discharge early. But based upon their conviction, not because they were juveniles or because of anything else, they just want to keep a closer eye on them and to protect the public safety and all the circumstances that arise from supervision while on parole. So in this particular case, if you get to the statutory interpretation and have to get to what ill was sought to be achieved, it was to have a longer period of supervision for what are the most serious types of offenders. We would assert that the question presented to the court today is primarily statutory interpretation, and we believe that the statute, you can get there from here. It's a question of what was intended in the conviction of the individuals. So we would assert that the decision of the underlying trial court was correct, and the trial court decision should be affirmed. Unless there are further questions, I'll waive all remaining time. Thank you.
Mr. Hill, thank you as well. Thank you for your arguments. And the case is now submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.